Following is a live broadcast of a Lone Star community radio program, recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and facebook.com/irlonestar. For more information on this show, please visit our show page at irlonestar.com/shows. To sponsor or donate to this program, visit our donate page at irlonestar.com/donate, or email us at lscrstudios@gmail.com, or give us a call at 936-666-1084. Lone Star Community Radio production and broadcast is possible by folks like you. So sponsor and donate today.
You are listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCC-LP Conroe, and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection with Tony and Cheryl. Tony Lynn Collins and Cheryl Ellsworth Jahani. We are two Texas licensed attorneys, and we are here every Tuesday on 104.5 and 106.1. Montgomery County, IR Lone Star. You can go to irlonestar.com and you can listen live, or you can listen to us live on Facebook. We are here today talking about legal issues, and what we wanted to talk about today is zoning enforcement, waiver.
Yeah, deed restrictions, your property, your enjoyment and use of your own property, and how it's affected by deed restrictions, zoning, and whether some of the deed restrictions that you may be subject to, or the zoning you may be subject to, have been waived or abandoned.
Yeah.
And you've got a history on that we get to hear about. I can't wait to hear about it. And then we're going to give you some law on, so you can kind of maneuver your way through this melee of information to decide whether or not you need to get an attorney involved if you want to use and enjoy your property and you think that right is being improperly taken away from you by your homeowner association or a government entity.
Like the city.
Right. Mm-hmm.
Yeah, so important. So we were talking about something that I went through when we lived in Dallas. We bought this big old house. We were across the street from, just to kind of give you an idea, and I don't want to talk about this, but Tony's making me.
Yes, I am. Because I love that you lived in this rich enclave of Dallas, and your neighbors were in the news, and you were just sort of living the life with your kids, and it's just a day in the life of Cheryl.
Right.
And this is
20 years ago
that our readers don't know about you. And so you moved to Dallas. Give us a little background. What happened? How did you even end up
I'm
there?
from Dallas.
Okay, you're from Dallas.
That's
all
where
right.
I'm from.
So you started out in Dallas. You grew up there. What was
I
the
went
background?
to high school, college, all that stuff.
What high school did you go to?
Newman Smith High School.
Okay.
That's Carrollton, actually.
Okay.
And then I went to University of North Texas.
Okay. And what was your
College back
degree
then.
in?
Back then, my degree was in psychology.
Okay.
Still is. I finished that, but it was in psychology. But anyway, we lived in this neighborhood that, the guy who was the president of Coca-Cola lived across the street.
Uh-huh.
The guy who ran, what's the guy's name? Vicente Fox is in Mexico.
Oh, okay.
Ran his campaign. Was our next door neighbor. Very nice people. A lot of our neighbors were very nice.
So how big was this estate you lived on?
It was, 3/4 of an acre.
Oh, it's only 3/4 of an acre. Okay. But was it a gated community like River Oaks?
It wasn't gated.
Okay, because River Oaks is not gated either.
Yeah. No,
But
ours was like that.
Okay.
It wasn't gated, but there were big mansions and all of that. And 3/4 of an acre in that neighborhood was a lot.
Okay.
But they were all on, relatively similar.
And what was the subdivision name? I'm sure it was a subdivision.
That's a good question. It was...
Because River Oaks is a subdivision,
right?
Our
And
listeners know.
it is a name. In Dallas, when you say Rockbrook, everybody knows where that is, or Straight Lane. That's
Okay.
where Ross Perot lived.
Okay. And how was he your next door neighbor?
He was not my next door neighbor, but he was down the street.
Okay.
But it was right over. You're not familiar with Dallas, but it was right over by Ursula, which is a private school for girls, Catholic high school, I believe.
I'm liking that.
Yeah, right there. And Lovers Lane, we were right off Lovers Lane. Anyway, you'd have to be from Dallas West and all those
Okay,
locations.
so you picked this house when you and your husband got married to bring your children up in. Would that be correct?
Right. Well, sort of, yeah.
And the house that you lived in, describe it a little bit for us.
Tony.
It had a gate. I know that your squabble was over something
A
about
fence,
a
the
fence,
fence.
but describe the house.
It was almost a 12,000 square foot house.
Okay.
It looked a lot like the White House. I mean, to be honest.
I love it.
Which is, I think, the reason that our neighbors made such a big, this one neighbor made such a big deal out of our fence. She, so anyway,
Your issue was with the fence, but the house itself looked like the White House, and I'm assuming you had an entrance to get to your house that may have been 500
it was a circular
feet or-
drive. It was a
Okay.
circular drive, and so and the house was white stucco.
Okay.
The house actually was purchased from us by the vice president of American Airlines.
Okay,
At
so-
the time, I don't know what he's doing now, but his name's Dan Garton.
Okay.
And he and his family, they actually lived around the corner, and they were going to do construction on their
And they
kitchen.
found that y'all were moving.
Well, no, we weren't. Well, so they were going to redo some of their kitchen and stuff like that, and they came down the street to look at our house to see what we had done because we remodeled this entire kitchen. And added tons of square footage. It was absolutely gorgeous. So they fell in love with the house and bought it from us.
Okay.
And we were glad. We were glad. But
And y'all moved to
and then
Colorado
after that, right? And after that, the house was actually worked with a decorator and all of that, and it was in several magazines and things like that. Yeah.
Now I'm going to have to Google it. So I want to see the house that was a designer house. And
Yeah, this was back in 2000, so you could maybe be able to find some stuff on it.
I can find historic stuff. All right, but your beef was what?
So we it's a white stucco house, boring, right? But it's a white house.
I love my house is white. I love white houses. All my houses
Well,
are
this
white.
was a very wide house. We had big pillars in the front and all that kind of stuff. So we wanted to redo the stucco. But first, we had to work on our circular driveway and the approaches as you come through the circular driveway. And we had this fence. So there's a white stucco pillars in between black wrought iron. And
Oh, that sounds beautiful.
yeah, it was pretty. And then on top of the pillars, there were lanterns, like black lanterns that match sort of the wrought iron. Well, we were trying to kind of move in a different direction with the same basic stuff to work with and take it a little from white to off-white anyway.
Okay, but it's important to me because this is what your beef was. How tall were these pillars and the fence? What was the size and all that?
Well, it's important to remember that in Dallas, the default, you can build a fence in front of your house, any house.
Really?
Up to 4 feet.
Unless do they have deed restrictions? Of course they have deed restrictions here.
But anything beyond 4 feet, what you needed a variance for. Okay. So these stucco columns were well above 4 feet. The wrought iron in between them was probably right at 4 feet.
Okay.
So we hired this guy to come in, and we were going to build this beautiful cast stone curbing and stone and stuff. A lot like you do, the stuff that you like.
Well, not quite on that level, but yes, the stuff that we like.
We were going to build,
Stone
so the guy comes in and just yanks down the stucco pillars and all of that stuff without checking about any restrictions or variances or
that's
whatever.
expensive.
So then when we started to build, the neighbors started having a fit.
Okay, and this would be one neighbor, all the neighbors, the homeowners
There was
association,
one
city.
behind it, and she tried to get all of our neighbors.
So at the time that this is being put down, did you get a notice from her, a phone call? What was the next step that happened?
Oh, gosh, Tony, this was 20 years ago, but it seems to me like we got a letter from the city saying that they had heard that we were planning to build something that was going to be in violation, and maybe somebody told us we need to apply for a variance. So then our fence guy who yanked the stucco one down, then
already
applied
gone.
for the variance. Yeah. Well, and so then we went through this whole hassle with the city, with our neighbors actually, but it was this one neighbor.
Yeah, because normally, as you know, because you're dealing with this right now in a different case that you're working on, normally the city doesn't even know. And they're probably not going to give you any grief unless you've got a neighbor that tips them off.
Yeah, I think that's what happened. I think actually because I remember a couple of meetings on our front steps with all the neighbors out there yelling and
Get a lemonade
upset.
stand?
No,
Shouldn't
yeah, but nobody cared about what we did with our fence except for this one lady around the corner in a tiny little bitty
Well, if it
house.
was going to improve the value, because what you were doing, it sounded like it was going to be an expensive improvement, then they shouldn't have had any issues, and they would have granted a variance in that sort of
Right.
neighborhood. But there was a lady that you said may have been maybe jealous, or maybe she just had a power issue. Lots of people feel like that, they're the ones that's in charge of cracking the whip, even if it doesn't matter because they're not looking at what the true injury is.
Yeah.
So this lady, did she call you, or did the homeowners association call you, or the city? I think you said the city.
No, you know what happened, Tony? They had a meeting. Our neighbors had a meeting, and that woman called the meeting.
Were you invited?
I don't want to say we weren't invited. I'm sure we were invited, but I think the first one we were not invited.
Right.
And so she started telling everybody that she was upset that we were going to spoil this park-like setting in the neighborhood, and that was gone anyway. You know,
right.
Because everybody else had. It was ridiculous.
What you were going to put up, would it have blocked the view of your house, or
no?
Okay,
no.
So now tell me what you wanted to put up. We know what you did have. You had iron gates about 4 feet, and then you had big columns with lights on top. What were you going to put in?
We were going to put up higher columns with cast stone in between the columns. I mean, I know our listeners, unless they're watching live on Facebook, can't see this, but in between, every 6 feet we'd have a column, or 8 feet or 10 feet, I can't remember. And then we'd have this cast stone and this stone walls and then this inset of wrought iron.
Okay.
And then we were going to have 2 gates that opened this way,
Okay.
like yours, but 2, because it was a circular driveway.
Right. If we were to take our other lot and put a circular drive in, we have 2 entrances.
It would be like that, except for we were going to have stone columns, every, I can't remember, 10 feet, 12 feet, 6 feet, 8 feet, something like that.
Okay.
It was going to be gorgeous.
Okay.
But it wasn't going to be 4 feet tall. It was going to be 8 feet tall. I can't remember.
So you wouldn't be able to see your property as well? Maybe
You could see it just as well. As a matter of fact, the Coca-Cola guy had big, tall entryway gate things. The person over here had huge stuff.
Did anybody that you're describing, your neighbors that were in close proximity to you, did they have a wall or a gate that was around their house that was similar to what you were getting ready to do?
Oh, yeah.
Okay. So that's
the problem is when you drive into that neighborhood, okay, and I don't know if our listeners will understand this, but it's like a circle, but it goes back. Tom Landry lived right back behind me.
Okay.
But you go in, and it's true that you did look to the right and you saw my house, and it was this big white house. Well, so from my house this way, everybody had high fences.
Okay.
Beautiful gates and all this. But from my house this way,
they didn't. They
didn't.
Ones. Okay.
So we were the fighting house, the where they were going to keep it a park-like setting forever, and they were going to win on this.
But that wasn't what the majority of the neighborhood looked like, and
just this one area back there did.
Okay. And so the grievance here, and what our show kind of is going to go toward, is you were trying to use and enjoy your property,
right?
And you did not believe that you needed to get any permits or any permission from you had a homeowners association or from the city to improve it to be the same in a similar.
And similar to what it was before.
As what it was before, and to what your neighbors had.
Exactly.
So you were just going about your business, and obviously the guy that was doing the work didn't think you needed it either, because he didn't even try to pull any permits.
Right.
And so what happened next?
We ended up before the zoning committee in Dallas. I think it was just the zoning committee.
Did you get, when you went, was it like a trial? Was it like a bench trial? Or?
At first, they just asked us what was going on, and we presented our different sides.
Was it like in a room?
It was a room.
Okay. So that wouldn't be too different from, like we were talking about last week, the appraisal district. If you're contesting your taxes,
right,
protesting them, then you go into a small room. Well, right now it's Zoom. It'd probably be Zoom now too if you had something like that.
Oh, yeah.
But first you're dealing with somebody on a low level, like it's sort of you're having an informal meeting. That's what it is. And then after that may or may not fail. A lot of times they've got the authority to go up to a certain level to give certain things that they can negotiate with you with. But if that fails, then you go to the next higher level, which is a formal, and it's still in a room with just a few people. You haven't gotten into a legal level yet.
We did that.
Okay.
We had 2 hearings.
Okay.
One, I believe, was informal, and the second one was formal.
And you thought things were going well in these 2 hearings, I'm assuming.
I thought the first one was okay. They didn't decide one way or the other. They said, okay, we're going to give you some time, put your facts together, come back before us in a month, and we'll talk. So I went around the neighborhood and took pictures, you know.
yeah, you're preparing.
And, yeah, did all that stuff. But I wish that I'd gotten an attorney. I mean, that's what we were talking about before, because the lady that was really against us putting a fence in, she didn't even want the fence that was there before, you know.
You could tear it all
She
down.
went and got an attorney. And it was really interesting because when
Why
you go,
was it, what was it, how she doesn't have was it for the association? I mean,
she was going to win.
that's crazy because she didn't have a beef against you. But you know what? Homeowners in a subdivision, and it's in the statutes, can sue each other. If your homeowners association doesn't sue you to stop something, an individual owner within that has a standing can sue you to keep it.
And it was
like
really
that.
interesting because it was this one woman. I went around and talked to several of our neighbors, and they were like, "We don't care what you do with
Right,
your
right.
fence. Do whatever you want,"
Yeah.
you know? And they were nice people.
Right.
But if they signed something, so I had a petition
Yeah,
and all
yeah,
that stuff,
I've been
they
there, done
signed
that.
it. And then they're like, "Oh, I shouldn't have signed that. Oh, no,
Right,
now I'm
then
involved."
they're like, I don't want to get involved in this. And then all of a sudden, the story changes, where they were so supportive with you.
Exactly.
After they signed something and they see there might be money involved, or they might, now it's going to be there's going to be a contest of some kind. They back down and
Yeah.
they're no longer
I know.
aligned with you. They suddenly almost change their tune.
I
And
know.
you know, because you've talked with them.
I know.
They're supportive. So, but we know this from a couple of cases that we've done together. Once somebody signs something,
Oh, yeah.
they've committed.
Well, and so, you know, they would say, "Oh, I didn't know why
But do
I
you want to
signed
go
that. It
forward
was-"
and hold them to it? Because then you're kind
Right.
of like,
And
what
this
is
is
the
your
damage to
neighbor.
your neighbors, right?
I mean, it's
You don't want to
a
be outcasted
conundrum.
every time you take your garbage out. Yeah.
Yeah, well. So anyway.
So what happened next?
Well, so we went to a hearing, then we had another hearing scheduled, and I just wish that I'd been loaded for bear. I wish I
Did you have
had
any
known
witnesses?
what was
Any of your
going
rich
on.
neighbors? Ross
No, but of
Perot,
course she did.
Tom Landry
You
didn't come
know,
in with the
well,
spitball?
actually, her witness was her husband. You
That's
know,
completely biased.
and
It
he was.
doesn't
I
count.
know, and it was so neat because the council, the people that were trying to decide this, they went around too. Okay, this woman went around and took pictures too, but she was like down on the ground taking pictures. We had
it looked like the Empire State Building.
with our approach, our circular driveway.
right.
We had built this stone fence, and it kind of curved in, and it had columns. It was beautiful. So they're down on the ground in front of our
Making
house,
it look-
taking, and I could see them say, "Oh, look at the angle that she took that." No, she was down on the ground.
Right.
They were very sympathetic with us, but her and her attorney just did a much better job.
And you, what was your takeaway from this? First, did you put the fence up? What ultimately happened? You didn't have a fence. The guy took it down. So what happened?
We put up a shorter fence.
Okay, but it wasn't the one you wanted.
And it didn't meet the scale of the house either, which was the problem with the shorter fence.
Mm-hmm.
You can't have this big, massive house with this tiny little fence.
Yeah.
It looked like a little picket fence, you know, in
Compared to the White House.
Yeah, it didn't look good.
You needed a White House fence.
Something like
Yeah,
that. But anyway, so my takeaway, as a matter of fact, I was so touched by how those council people have to sit and listen to all this garbage all the
do.
time. It made me sick. So the takeaway was, even back then, I was very appreciative of those council people. I wrote them this big long letter, and they all went crazy about how we lost, but we were actually good losers, and felt sorry for them. They thanked me, each one of them, profusely over and over about
Well,
how
you were also
sweet.
pretty influential. You lived in this,
Oh, yeah.
rich area.
Oh,
and,
yeah.
you probably barbecued with
Oh, it was
Tom Landry. Did
ridiculous.
you barbecue with Tom Landry?
No.
You should have.
Boy, I wish
He's
I
a neighbor.
had. Oh, I loved him.
I mean, I can only imagine that your kids were selling Girl Scout cookies and going door to door and maybe getting an autograph or something.
Yeah, they used to sneak across Inwood Road with our neighbor who ran Fox's campaign. I can't even remember their names. I feel so terrible about that. But drive across this on their bikes, this super busy road to get to the 7-Eleven so they could drink Slurpees.
That's so funny.
Yeah.
See, they're just people. They
They're-
just have a lot
but
of
it was so
money.
dangerous. Oh, yeah.
Okay, so you put the smaller fence down. You felt defeated because this woman was more prepared than you in fighting her case. If you had gotten an attorney,
I had no idea
that
what I
and
was
you
facing.
had the money, you just didn't do it.
Just didn't do it.
That she was just more. I think it could have also been a part that she was so aggressive that the bulldog versus the
Very nice.
the nice people were they just didn't. It was the path of least resistance.
You know what? There's a lot of truth to that because that's true.
Yeah.
She was.
And it's also who a lot of stuff goes. And I think even in the cases that we work with right now, And I tell a lot of my clients this. It's not necessarily what you're looking for. It's who is asking and who they know and who they've got representing them. Because in small communities, and I'm going to say that Montgomery County is a small community. We operate like a small community.
Yeah.
If you can get the right attorney who knows the right judge, the right person, or the right congressman or whatever on their side, it's going to go a lot more smooth than it would otherwise. And so you've got to weigh all this stuff in. It's not always justice will be done.
Right.
It's that fight to get to the justice, and it may not happen. And a lot of times things aren't right. And we know that even in the Bible, I go to the Job. What happened to Job, where he was doing everything right, and then the devil.
And that's what happened.
And
He
so
was doing
tell us
everything
real
right.
briefly, so you know the Bible backwards and forwards. And what happened with Job, so that our listeners can hear sometimes justice isn't done.
Well, Job basically was doing everything right, and that kind of made him a target.
Yeah, and he had a lot of land and everything. God
he was
loved
one
him.
of the
and,
richest men alive at that time.
And where was he from? I can't remember. One of those Jordan or Israel or whatever.
I mean, that Job is old school.
Right, but he was still over there, and
Well, no, he was from there, but it was like.
we're still talking about where Israel and Jordan.
Well,
and
I don't
Iran.
think he was from Canaan. Job owned a ton of land.
Right, so he was prolific. Kind of like
yeah, I don't
our
remember where he
Dallas
was
community,
from.
but
Yeah.
but he had everything, and the devil said, "I think." Well, how did it go about that Job lost everything?
He said, "You think that Job, God says to Satan, have you considered my servant Job? He's got all this stuff and everything, but he still honors me and remembers me."
Mm-hmm.
And Satan said, "You think he's doing that for nothing?
And the devil was like, "Yeah,
Satan said he's doing that because of all the stuff you give
yeah,
him.
you bought him."
You take it away and he'll turn on you like that."
Right, uh-huh.
So God said, "Okay, let's see if he does."
And
So
God
that was the
took it
real question.
All away.
He
God
did.
took it all away.
He let Satan. He didn't kill him, but I don't think that would have
His
even been the
family
point.
got killed.
All of his kids.
All his land. Everything. God took everything away. And Job was doing everything right.
He really
Just
was.
like people that are following the law. He was doing everything right. But Job continued to honor God no matter what, because he knew it was right. And then God honored him back by giving, what was the saying? He got
double, and the only thing he didn't get double of was his children. He got the same amount. I don't know how that happened because I'm sure his wife was old, but I believe that he had 3 boys and 3 girls, I think. And they were beautiful. As a matter of fact, I think it's interesting that Scripture makes a reference to the beauty of his daughters. One of them was actually named Mascara, the translation for mascara, which is interesting.
really?
She must have just been gorgeous.
Yeah, yeah.
So he
I
got
don't know
double.
about- That's a good, I'm going to have to remember that for the next
I don't know what
Courtneys
her
we get.
original name was, but whatever the translation is, it can translate into mascara.
So anyway, the bottom line was that he continued to honor God, and it wasn't all about it. Love of money was not the root of all evil.
And he wasn't honoring and serving and loving God because God gave him stuff. Somebody finally answered that question for us. And if we know about Scripture, we know the answer to that question is in Job.
Right. But that goes back to you were doing what you were doing as much as you could the right way, and this lady was
Just decided.
against it for some reason. And sometimes it looks like justice is not done.
And also, Tony, when you need to get an attorney, you need to get one.
Yeah.
And, I did represent myself.
'Cause you were
but
thinking, this
I
is
lost.
easy.
Yeah.
I went to
thought this
school.
makes perfect sense.
Yeah,
They're going to see this.
So this is the black and white. This is just a community. These are my friends.
Sure.
This is just they're going to hear the black and white of it. They're going to see that this is the law, and
Right.
I don't need an attorney. Why should I?
Sure.
I'm not going to bug them. I'm not going to make mountains out of molehills. No. And then I bet you were
Exactly.
not happy later when you realized justice wasn't done because some honorary
It
woman.
bothered me a lot, yeah.
Yeah, and it weighs on you because you're like, I'm doing everything right. But God always has a plan, and you can't let justice not being done get you down. You have to
Right.
continue having a good attitude about it and going forward. And that's why we're here today to say what happened. Well, you sold, but ultimately, I think you said that you bought like that mansion on the hill. You built some massive mansion in Colorado.
We built that.
And
yeah.
so you've lived the good life, the life that we've all wanted to live. You've lived that. And so, but today, how that ties in is to deed restrictions and zoning. We don't have zoning here in Montgomery County, but they do have it in Dallas. But I believe that probably even in your rich area, your River Oaks type community, they probably also had deed restrictions that touched and ran with the land. And there may have been something there that also said, you only have certain limits. So you had a double whammy in Dallas. You had city zoning, like they have in Houston. If any of our listeners have property out in Houston too, they have to comply with that. But as we know, the city isn't going to know. They're too big. They're not going to come down on you unless somebody tips them off and they know somebody and they make enough noise. So kind of getting along with your neighbors and kind of tit for tat goes a long way. Unless you've got some unreasonable person like this woman that just
Right.
was either jealous or just had a power thing going or whatever. All right. So that ties into waiver and abandonment. So you've got some law on what that is. And so if we have just so our listeners know, just to recap briefly what deed restrictions are, and it kind of goes along with what zoning is, but zoning is a government sort of deed restriction. Deed restrictions are set up by homeowners association when the developer creates it, or they can be set up later. But I'm going to read what that definition is briefly so people know the legal description, and then you're going to tell us about when a deed restriction exists, how you may be able to get around it like you should have in your community in Dallas.
Right.
And like this is all across the board here in Montgomery County. We have subdivisions and we have older ones and newer ones, and there's deed restrictions that look like they've been abandoned and waived, and your neighbor's doing something. Why can't you do the same thing?
Sure.
What's going on
No
with
one
that?
complained about them.
Yeah, so why? Who do they know that and that same neighbor may be the one that's coming down on you, and that's not fair either.
Right.
Where's the justice? All right, so here's deed restrictions. Deed restrictions are private contractual covenants which limit land use, and there's an underlying tenet in the law that says that, and it's not just a tenet; it's the law that you should be able to have. You should be able to enjoy and use your land as you see fit if you're not hurting anybody, right? That just is the way it is. And that's why deed restrictions have been created so that you can keep the value of your own land and your neighbor can't come in and put a nuclear waste dump site next door and ruin the value of your land, okay? So they're more appropriately called restrictive covenants, but commonly called deed restrictions or simply restrictions. They are called, like I say, just restrictions. Documents containing restrictions historically were the deeds to the initial property owners in a new development. So they run with the land. They go. You can look in the records to see if a public road was put in, or there was a restriction that only one neighbor could use something, or whatever. I'm paraphrasing here because I'm thinking about another one of our listeners who bought a piece of property that had a road on it that now a government entity is saying that was public, but it's not been used for probably 50 years, and so it's probably been abandoned, and they now want to use it because it's easier to get to it through their private road than another outlet. That's not fair. So you have to look at whether that's been abandoned or not. Now, but way back in 1900, way back in 1850 or 60 or whatever, when the first deeds that show up in the record that run with the land, they may have had some restriction in them that may or may not be enforceable now, but we're going to get into that in a little bit. Although the method is still utilized, the more recent approach to set forth deed restrictions in separate documents entitled Declaration of Covenants, Conditions and Restrictions, known as CCRs, Restrictions and Restrictive Covenants. That's how they're referred to now by your homeowners association. Restrictions are seen on the face of the recorded subdivision plat generally. If you can, normally when you buy a piece of property, the plat, if it's a subdivision, and a lot of them are, they'll have the restrictions on them too. There's a lot of places you can
Just
look.
list it out.
Yeah, they'll list out there. And if it's not in your restrictive covenants, they'll always refer to the plat that may have a restrictive covenant in it, like it'll show public road on there. And it's like, okay, you're on notice because the public road's on here. That's different from just a few numbers that are slapped on the plat that mean nothing.
Right.
So it all kind of ties in. I was telling my friend who asked me about this that if in doubt, you can save a little bit of money and do your own research if you get a landman, somebody that's not biased, like your next door neighbor up there in Dallas, to actually run the title, to get a title run sheet. That's what the attorneys rely upon for a little bit of money to run the title from the sovereignty of the soil to move forward with it. Like we're still in a lawsuit right now that if the entity, the developer, had run a title sheet, they'd see that they will lose this lawsuit because if they had gone from the sovereign forward, they'd see that they don't have, leg to stand on because they don't own the land. But that's kind of here to there. If you do a run sheet, and that's typically what part of your evidence is in a lawsuit with regard to restricted covenants or entitled ownership, this run sheet done by a landman, an unbiased person.
And you're a landman, aren't
I'm a
you?
landman too, but they will usually go into that county, whether it be Walker, San Jacinto, Grimes, Harris, and they'll go from the sovereign, and the sovereign is going to go from when the patent was established by the state of Texas, and there's some more that goes to it. But if you can get one of these people, and you can ask on our website, we can forward you names of people that we don't have a tie to them, but they are landmen that can run land title sheets. They will run these title runs that show you all the deeds that apply to your land. It's really interesting to see who owned it before.
Oh, I bet.
And you could have done that too had you gotten an attorney for your property in Dallas.
How would that have helped me, though?
And well, because it could show that the person that owned your estate in that very rich area, going all the way back, that maybe there was an exception to
right.
and that should have applied
And would run.
But today, what would have helped you had you known back then are whether or not those deed restrictions in the zoning, if there was a loophole, and the loophole would have been whether they could have been waived or abandoned because of the usage. And in your case, I thought it would have. So what?
And that was my argument before the
and an attorney
the
could
committee
have
could have made it
very
effectively.
easily been your bulldog,
Sure.
gone up there and said, no, you were wrong because these people were waived, and look at
Exactly.
the angle, and their
Exactly.
evidence isn't as good as mine.
And we could have won. I really think we could have won.
And
you
you were
know?
and you were downtrodden, and you should have been toasting with margaritas with Ross Perot and the guy that owned American Airlines, and you didn't because you didn't know then.
No.
But tell us about the law on enforcement and waiver.
Waiver and abandonment, right? Is
Yes.
what Tony's talking about. She's talking about abandonment, and I think that it just kind of speaks for itself. But what it is that you have these restrictions that have been abandoned
Okay.
for. I mean, what's a long enough time, Tony? Is it going to tell me, or I mean?
Yeah, well, go tell us what the
Okay.
law is on abandonment. I think that you got the definition.
Here's the law.
Uh-huh.
Waiver, abandonment, restrictions may be waived. The rule for waiver of a deed restriction has been stated as follows. Restrictions may be waived, but in order to establish a waiver of a general scheme or plan for the development or particular area, it must be shown that such plan has been violated to such an extent as to reasonably lead to the conclusion that if in fact it has in fact been abandoned and that unsubstantial violations thereof or the fact that a complaint has not objected to previous violations of such restrictions, particularly where they did not immediately affect the enjoyment of his own premises, will not prevent him from maintaining an action for injunctive relief to prevent substantial violations thereof or a violation which would materially affect his own premises.
And that's basically an affirmative defense saying, yeah, the deed restrictions say I can't do this, like with your zoning. It's not like a deed restriction. It's a government entity that first established it, not your homeowner association community or the developer saying you can only have this. But you're telling me that in that community you had other very lush houses that had exactly what you were doing.
Right.
So why were you being denied something that they had done?
Right.
Because it probably was abandoned or waived. And the law says that if you can show that no complaint was made about a neighbor that did it over a certain period of time, then it may have been abandoned by this law. There's a little bit more to that. Waiver and abandonment are very similar.
Was I just reading abandonment
I think
or
you were just
waiver?
abandonments. Because I'm going to tell you a little bit about waiver if you don't have that.
It just says restrictions may be waived, but then it goes on to talk about abandonment. So,
Okay.
and what you just said, no
Okay.
complaint and all that.
So, I'm gonna tell you a little bit about waiver and abandonment because they are so similar. Waiver and abandonment. Abandonment means that that basically nobody even ever brought it up, and it's been so many years it's been
Right,
abandoned.
right.
Waiver means that they were aware of it, but they didn't go after you. Okay. Now, I'm going to give you a little bit of law on waiver because it's a little bit different than abandonment, and it's kind of important because you cannot apply waiver. It's not going to be defense if in your deed restrictions or in the zoning it literally says expressly waiver doesn't matter, and that's in a lot of the new deed restrictions.
Oh, really?
It can say there is a non-waiver clause, and so you're going to have to rely upon abandonment and some other stuff. But given the rapid expansion of Texas cities and changing nature of many subdivisions, which is what happened with yours, deed restrictions sometimes seem antiquated, just like with your wall. This is especially true when once residential streets are now busy thoroughfares and more appropriate for commercial use. That happened with 1488. It's happening when you have a little 2-lane highway. Let's just go with 2854. Not even a highway. They were just like mail routes. Old Conroe is a good example. It was a horse route. This is a road that's not paved on the side. It's got the ditches and it's not commercial. But now suddenly we've got a government entities and developers around that area are saying, hey, Old Conroe used to be a horse route from, it used to be called Old Magnolia, Old Conroe Road for a reason. You got from Old Magnolia to Conroe by this old road. But the bridge got washed out where West Fork and where the West Fork, San Jacinto and Lake Creek were, and there's 2 bodies of water, and it got washed out. And so now they're trying to make this into a thoroughfare. It's not there yet. And
we're talking I know the answer, but this is headed straight to your house when I'm going down 1488.
Right. And it connects up to where Ed Sargent,
Ed Holcomb.
Ed Holcomb Sergeant Road
Ed
is.
Holcomb.
That's where it would connect up if they can make the connection, which we believe that they shouldn't be expanding Old Conroe Road where a subdivision is right now. Why not go where they've already got paved 2-lane, go through the subdivision next door where they've already got the right of way? Why are you taking away someone's land through eminent domain or whatever they are trying to do when it would be less expensive to go where you don't have to do 2 bridges over 2 bodies of water? You should go where the old bridge was. It was a little bit further over. There's a lot of arguments where it's just whoever's arguing and has the most power, whoever's got, I think, the greased palms looks like what's happening, and that shouldn't be the way it is. So just like with you in your subdivision in Dallas, you can't just sit and let that happen. You have to.
Well, you hit the nail on the head when you said it was kind of the nice neighbor against the aggressive neighbor.
Right.
It's that when you said that, it's almost like you were in the room with me. That's exactly what happened.
Right. You have to stand up for your rights,
Yes.
and you have to get some support behind you. And then, more important to all of that, you have to logically take yourself out of that, realm and say, logically and more efficiently, this is an alternative to this, and this is why. And give them options that are, why didn't you go this direction? Because that person over there or that landowner over there has got more money and they can fight you because they seem more powerful. No. Logically, if more people are affected and there's more damage being done it's just that they're not screaming about it, it should go this other direction. And so you need to get with, TxDOT and the state and the federal government who may be giving some money to fund that, your local communities. You need to step up and everybody get together that's being harmed and not sit back and hope one person's going to talk. Everybody's got to talk. And I think that was kind of what's going on there. But the example was Old Conroe Road is a good example. It's just one that I kind of thought of right now, where you may have a small street they're trying to make into a thoroughfare when that doesn't need to happen. But it may be, in this
Wouldn't that be really bad for your neighborhood?
It would, but in this instance, it's not even a thoroughfare because there's no connection, because there's no bridge. There's no way to even get there right now. And so why are you in the planning stage is when you need to stop it right now, because it's ridiculous that they're going to be harming people that live there and taking their front yards away when they can go a different route that is more efficient, more economic. There's a lot more efficacy to go a different route and go straight than to do, because some developers got billions of dollars or whatever they're thinking, I think it should go this way and this will help them. So there's just, the little guy needs to stand up and maybe get an attorney.
Yeah.
Okay. So that being said, landowners restricted in the use of their property often look to neighboring uses, their neighbors' uses, like you did, thinking that's the way that may be the argument, right? Which could be, but that may not be the whole argument. So you need to get perhaps an attorney involved and maybe some local people that will help you that don't have a dog in the fight, because they're the people that are going to be argue the best for you. They know the powers that be. They know the commissioners. They have lunch with them. They know the judges. They know. So you do want to get some people that have some connection, okay? But you also want to bounce off them. You may not be right. You want to present your case for maybe a small fee for them to analyze your situation for you, okay? When those uses are inconsistent with existing deed restrictions, important questions arise. And in your case with the wall, the uses that you wanted to use were in complete alignment with what you wanted to do. You just had one rabid dog neighbor that was giving you a bad time. And apparently you didn't even have any beef with her until she decided to get into your business, all right? Have my deed restrictions been waived? In your case, I believe that they were. If so, does the waiver allow me to use my properties I desire? In your case, I think that was the case. You didn't have the right representation for it. As with most legal questions, the answer is it depends. Okay. So what is waiver? Waiver is the voluntary relinquishment of a known right. There's some case law to that. In this one, they're referencing Jim Rutherford Investments versus Terramar Beach Community Association in the Houston Court of Appeals. A waiver is either made expressly or indicated by conduct that is inconsistent with an intent to claim the right. And I could reference the cases here, but if you email or Google us or whatever, I can give you those cases. That's not really important for what we're talking about today. But basically, that's what happened in your case. It had already been waived because your neighbors had already done this and nobody had put up a fuss about it. All right. So the zoning ordinance had been waived. Generally, waiver is an affirmative defense on which the defendant bears the burden of proof. So you can't just say it was waived. They've got something in writing that says, here's the zoning law, here's the deed restriction, here's the covenant. You can't do this. It says it right here, okay? But you're saying, yeah, I know it says it right there, but let's look, the affirmative defense, like in criminal cases, if you murder somebody, it's not murder.
Self-defense.
Because self-defense is an affirmative defense. Like with aggravated sexual assault, date rape. We had sex, but the affirmative defense is she solicited me, she paid me, or whatever it may be. So the affirmative defense is, it happened, but there was complete consent between both parties. This was just, this was just sex. This was not a sexual assault. So there's a lot of things that kind of kick in. Here, the affirmative defense is you've got to bear that burden. You want to put the wall up. Now you got to go take pictures. Now you got to go find the law that says the certain percentages change. You need to show that nobody was harmed by it. So you had a lot of work to do to put your big wall up, but you didn't do it. Now, this particular case, it was Philadelphia Indemnity Insurance Company versus what? Your insurance company may also kick in and represent you in some of these cases, depending on what kind of insurance you have. So look at that too. You may be able to fall back on, hey, insurance company, I've got this umbrella insurance, and you're supposed to represent me on this. So go there too. Your defense may be covered by your insurance company. So don't. An attorney might be able to help you look at that too. So that consultation fee may be well worth the money. In this particular case, it explained that the defendant bears the burden of proof on all affirmative defenses. Now, a property owner being sued for enforcement are the breach of restricted covenant usually asserts waiver as a defense. You can assert, why hold back? Assert 10 affirmative defenses.
No kidding.
Don't limit yourself to one, because if you have to go up on appeal, they're going to say you never brought it up and you've waived it.
Right.
So just put, in there again, it's not going to cost you any more if you've already got a defense going, if you've got a lawsuit going. However, with increasing frequency, property owners are taking the initiative and filing suits to obtain court determinations that certain restrictions are invalid based upon waiver. These suits are usually filed under the Texas Uniform Declaratory Judgment Act. And that's in Texas Code of Civil Remedies and Procedures Code at 38. And the reason that's an important code to look at, to make sure it's in your petition, even if you're doing it in small claims court, the same law applies, is because you can get your attorney's fees, if you have an attorney, reimbursed under this.
What's it called, Tony?
It's called the Texas Uniform Declaratory Judgments Act. And you can find that under Texas Code of Civil Remedies and Procedures 37 and 38. Okay, but if you just put that in there and you Google it, you can find it. The internet is wonderful these days. Now, under Texas law, restrictive covenants may be waived, and the waiver is ordinarily a question of fact. Okay, not law. In your particular...
Really? Okay.
Yeah. So, as a matter of law, they would have won. But as a matter of fact, you have to show the facts that show that it has changed. So don't give up on that. Proof required to establish a waiver of deed restrictions. Very important. To establish a waiver in a deed restriction case, the non-conforming user, and that would be you with your wall, must prove the violation then existing. The violations then existing in the neighborhood are so great as to lead the mind of the, quote, average man to reasonably conclude that the restriction in question has been abandoned and the enforcement waived. Among the factors to be considered by the average man are the number, nature, and severity of the existing violations, any prior acts of enforcement of the restriction. Like in your case, you could have shown that other people had already built walls and nobody ever had a problem with it. And a lot of them, the number and the severity. Whether it is still possible to realize to a substantial degree the benefits intended. by the covenant. In your case, it wasn't, because you're going to be improving the neighborhood and making it more like your house. Using this analysis, non-enforcement of the covenants against the smattering of owners in violation is generally insufficient to demonstrate abandonment. We're talking about waiver, though. On the other hand, if virtually all the owners on a certain street are using their properties for commercial purposes, or have walls up, or have fences up, or whatever the case may
Or
be,
carports.
a residential use only restriction, or a carport for that example too, a better argument for waiver may exist than abandonment. All right, beware of express non-waiver provisions in the deed restrictions, because if you've got a non-waiver provision, the court will automatically look at that non-waiver, and you can't use that. Courts will find a non-waiver clause ineffective only if the party seeking to avoid the covenants can demonstrate a complete abandonment of the entire set of restrictions. So you can't use waiver if everybody else is doing it. It's something you're trying to do. If this provision is in your deed restriction or is in the zoning law, it says non-waiver provision, and that provision is going to look a little bit like this. Invalidation of any of these covenants by judgment or court order, or the failure to enforce any of the said restrictions at the time of the violation, shall in no way affect any of the other restrictions which remain in full force and effect. And that one may not be the exact waiver restriction I'm looking at. They're all different. All right. So we need to continue this next week to finish up waiver and amendment.
Right. We want to thank you guys for listening. You can listen to us tomorrow, our podcast, Google Play, and iTunes, and you can watch us later on Facebook. We want to remind you to
serve God by serving others.
Have a great week.
Today's show was recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and all rights and ownership are reserved to Lone Star Community Radio. For more information regarding this program and Lone Star Community Radio, visit us online at irlonestar.com. Lone Star Community Radio is Montgomery County's community radio station, serving the community with local programming on TV, radio, and online. If you enjoyed today's program, please support us by sponsorship or starting your own show. Contact us today by phone or text at 936-666-1084 or email the station at lscrstudios@gmail.com.